Showing on this episode of the program, another senior advocate shares with Law Weekly his views on some of the discussions from the recently concluded National Summit on Justice 2024, jointly organized by the Federal Ministry of Justice, the National Judicial Council (NJC), and the Nigerian Bar Association (NBA). Also showing on the program, highlights from the Women in the Profession WIP Nigerian chapter event for female lawyers on strategic rainmaking, empowering women for the future. Plus our recap of the top trending stories in the courtrooms. Hello and welcome to the program. I'm Shola Shoyele. My guest, Senior Advocate of Nigeria, Olukayode Enitan, believes that the legal profession needs to prioritize good character and appoint into offices persons with proven integrity. Against the background of the recently concluded National Summit on Justice, which held in Abuja about 2 weeks ago, I began with his views on the key takeaways from that summit and what the legal profession should focus on in terms of reforms.
I believe everyone agreed that there is a challenge, and the challenge is deserving of solutions. So, I think the first, like somebody said, the first key to solving any problem is to first agree that there is a problem. And at that summit, everyone was of the firm view and agreement that there is a problem. Now, solutions. Each of the speakers and participants, both in the papers presented and the comments that were shared, provide solutions. But for me, what was key and which agreed also with what my views had been, is what Professor Yusuf Ali, SAN, said. He emphasized the issue of character. And the problem is not really with the system or the mode of appointment. It is the character of the appointer and the character of the appointee. Once we are clear that, yes, we have appointed men and women of integrity, it does not matter who appoints them. And for that to happen, it has to be merit-based, and for everyone to appreciate the fact that we are doing this on the basis of who is the most competent. So we need to focus on who are these individuals that we are appointing. Let them be those who have the intellect and the character to do the job of adjudication. So for me, that was very, very instructive. Again, it was also agreed that there is a need to do some tweaking with the concentration of power in specific individuals holding specific positions. So that is necessary. Otherwise, which is what is existing now, you have one person who's taking a decision here, and he goes to the next body, the same person is still there. So you need to have some measure of independence of opinion, such that no one feels, oh, I must go this way because I'm not sure what's going to happen next.
Because you've touched on the issue of merit in the appointment of justices, I want us to dwell on that a little bit deeper. The situation where we've seen in recent times where judges put forward their children, their siblings, family members, even mistresses, as we've heard, for appointment into judicial offices. Did the summit touch on that? Because I mean, even the CJN has been called out in recent times on these issues of nepotism. So did the summit address issues like that?
I would not say because that was not a specific item of discussion. However, before the summit, that had been in the public domain. For me, anybody can aspire to be a judge or a judicial officer. The question is that individual worthy of that office by his own creds. If exams are done and the person passed and passed extremely well, the fact that he's the son, daughter, or friend of anyone should be of no moment. It becomes an issue where that individual is a mediocre. If he's a mediocre and then you impose him or her over and above other people, then there is a problem. I have no problems with everyone being somebody's children. What I have an issue with is this person is undeserving, does not have the intellectual capacity, lacks the moral capacity, and is totally unable and unfit for an office, and then you put the person there. Then there is a problem.
We've heard that some bills will be put forward by the AGF as a result of the outcomes from this summit. While we await those bills and maybe the public hearings that will follow, what in your own views are the practical things that you think that we can do to make our justice system work better, to put reforms in place?
Timelines. We need to set timelines, and we need to enforce those timelines. Now, by timelines, what do I mean? Why are we in court for 6-7 years at the trial court? It's totally unnecessary. So set timelines. If we set these timelines, and everyone, and for me, I'd also want a compensatory cost regime. If you file a frivolous action, you should be made to pay. That is what operates everywhere else but in Nigeria. You see someone, he goes to court. He knows he has absolutely no reason to go to court, but he files his action, holds the hand of the other person, and for the next 4 or 5 years, they are going up and down, and then someone goes on appeal, 10 years, they are back in the high court. I want timelines. I want a compensatory cost regime such that if you make the mistake, you even defend a case that you should settle, you are made to bear the cost. Once counsel and litigants appreciate the fact that I should settle and you do not settle, then you are going to pay. You shouldn't go to court. You go to court. You are going to pay. Then we will all begin to sit up.
Away from that interview, we move on now to the Women in the Profession Nigeria Chapter Roundtable Breakfast Session for female legal practitioners on strategic rainmaking, empowering women for the future. Here are some of the highlights from that event. The Roundtable Breakfast Session of the Women in the Profession Nigerian Chapter, held on the premises of the Tier 1 law firm Udo Udoma and Bello Osage. Gathered here in this meeting room are female legal professionals from different organizations, from litigators to commercial lawyers, arbitrators, in-house counsel, public office holders, and many others. The women are excited about the opportunity to learn and share ideas on the theme, Strategic Rainmaking, Empowering Women for the Future. They are also excited about the lineup of speakers. South Africa's Tamsin Fremantle has extensive experience facilitating African capital markets development, and she led discussions on how to approach business development, brand positioning, and client management.
Don't think that just because you are the only woman in a meeting of senior financial people that you shouldn't be there. And that goes to that point that I said was made by a female Nigerian lawyer, which I loved, which was make space for yourself at all tables. Don't think that you don't deserve a space. And I would say that 25 years ago, not even 15 years ago, I think 15 years ago I was probably okay. But 25 years ago, when I was starting out, that's what I would have said. You have earned your place at the table, you deserve it, and now contribute the way that you can because of who you are.
This was followed by a fireside chat with Dr. Mama Bello Osage, partner emerita of counsel, at Udo Udoma and Bello Osage, which she co-founded about 40 years ago. In 2019, she retired from her role as senior partner at the firm, but continues to offer her expertise and experience. Her pivotal role during her career continues to inspire many old and young lawyers, and this group of female lawyers gathered here are desirous of getting practical insights on how to navigate the legal landscape, build a successful legal practice that will transcend generations and leave an enduring legacy for future leaders to follow. Dr. Bello Osage did not disappoint. She talks about what the journey was like in 1983 when she co-founded the law firm with her partner, Senator Udo Udoma.
I think we were very clear that we wanted to start a firm that was not what had been the traditional litigation firm of Nigeria many years ago. He and I decided that we wanted to have a firm that was primarily a corporate-facing law firm, so one that dealt with businesses. And we wanted a firm that was structured in such a way that it would live beyond us. So we were looking at, I guess, primarily American models, to some extent the British models that had started becoming better known, I would say. We had therefore to think about what is it that would keep a firm going beyond us, and thinking of things like who would we want to work with, how would we ensure a succession that made sense, how would we ensure financial viability. These were some of the concerns that we had at the time. And that required building what I guess now would be a brand, but I guess we then thought more of as a reputation, a place which would make a difference. And I felt particularly strongly that it was important to make sure that it would be a firm where women could work comfortably. And it's an issue that I think a lot of firms didn't necessarily think about because they happened to be started mainly by men.
She also talks about the need for a business development plan, even with starting up as a law firm.
What does a startup go through? You are trying to find clients. You are trying to establish what your market is. There's so many things that are relevant in a startup that relate to the establishment of a law firm as a business. What you do as a lawyer is only part of the business. It's like selling milk. I mean, you are providing a product that effectively comes from your brain, but that's what you are selling. So think of it in that respect. And that's when I began to realize that actually we needed to be more deliberate about the business side of the law firm and not just focus on the
reputation,
law,
like what you started
with. Just saying, oh, I'm a great lawyer, and then you sort of sit around and it's like things will fall in my lap because this is the case. Sometimes they will, but that's not what is going to sustain the firm. Think long term. You have families, you have children, you are creating value. What are you going to do about transitioning that value to your children, whether it's by way of money or whether it's by way of business? Don't just assume, oh, it's fine, it's keeping me busy, it's paying the bills, and when I retire, then what? When I die, then what? That's not what I think we seek to achieve. So I certainly wanted a firm that lived beyond me, and I think I'm grateful that the firm has actually been able to pay me.
She also speaks about how she was able to juggle wifely and motherly roles with being a co-founder of a growing law firm.
I think that anybody in that sort of position, you have to create an ecosystem of support. and it has many pillars and many legs. And I talk about family, including husbands. I relied on, to some extent, my mother-in-law. Obviously, I didn't have family locally. And I give a lot of credit to my nannies at the time. They were extremely helpful to me. And what I liked about them was the fact that they acknowledged that they had a role in developing the children they were looking after. So it's one of the things that I always say to people, please treat your staff well, because they can support you in so many potentially unacknowledged ways, but they can make an immense amount of difference.
With initiatives such as this, the leadership of Women in the Profession WIP Nigerian chapter reiterated its vision to continue to serve as a learning and leadership resource center for the development of the Nigerian female lawyer, while providing an inclusive and safe space to network, seek support, develop capacity and leadership skills. Thanks for staying tuned. The Inspector General of Police, Kayode Egbetokun, has stressed the need for lawyers working for the Nigerian police force to uphold the sanctity of the legal profession and the rule of law in the administration of justice in Nigeria. He was speaking at a meeting with lawyers in the employment of the Nigerian police force in Abuja. Mr. Egbetokun reiterated the role of police legal prosecutors and advisors in ensuring adherence to the legal procedures and human rights principles. The Inspector General of Police also urged all police legal officers to remain vigilant in safeguarding the rights of citizens and to step up their game in the defense of the country.
As esteemed legal officers of the Nigerian Police Force, you bear the responsibility of upholding the rule of law and ensuring the dispensation of justice. Your mandates demand impartiality, objectivity, and adherence to legal standards in all endeavors. Moreover, in addition to your specific duties, you are entrusted with the broader responsibility of integrity and independence within the legal profession. You must therefore specifically show commitment to upholding ethical standards, preserving confidentiality, and averting conflicts of interest. I urge you all to discharge your duties with diligence, integrity, and unwavering commitment to justice. In the face of multifaceted challenges confronting our nation today, from terrorism, armed banditry, to kidnapping and armed robbery, our officers all over the nation have exhibited commendable bravery, professionalism, and dedication. However, collaborative efforts are indispensable. We rely on the expertise and guidance of our legal officers to ensure the legality and efficacy of our operations. As officers in charge of legal at your respective commands and formations, you are pivotal in providing legal counsel, prosecuting cases, and ensuring the robustness of our investigations. Your contributions are indispensable in constructing cases that will withstand judicial scrutiny. Against the backdrop of recent reforms in our criminal justice system, including the Administration of Criminal Justice Act 2015, the Police Act 2020, and the drafting of the Nigerian Police Regulations, your role is pivotal in advancing our legal framework and operational capabilities while upholding justice. Addressing the incessant challenges posed by garnishee orders demands our urgent attention. These legal instruments employed to seize assets or funds to satisfy debts or liabilities have become recurrent across commands and formations. While fundamental to civil and criminal proceedings, the complexity of the process necessitates our meticulous attention to detail. I implore you as officers in charge of legal to prioritize the resolution of the issues of garnishee order. targeted against the police. Understanding the legal framework, diligent documentation and collaboration with relevant agencies are therefore paramount. Embrace international best practices, stay abreast of legal developments, seek guidance where necessary, and maintain accurate records. Let us collectively endeavor to ensure that our legal system remains a beacon of hope and justice for all. Through our concerted efforts, we will surmount the challenges posed by garnishee orders and foster a just society in Nigeria. Let us strive to cultivate a legal landscape that is fair, impartial, and accessible to every citizen, irrespective of background.
And just before we go, a quick recap of some of the top legal stories in the news.
We begin with the report that the Lagos High Court sitting in Ikeja has granted the request of the defense team to recall the first prosecution witness in the trial of the former governor of the Central Bank, Godwin Emefiele, over allegations of abuse of office. Justice Rahman Oshodi granted the request at the instance of counsel to Emefiele's co-defendant, Senior Advocate of Nigeria, Kazeem Gbadamosi. Gbadamosi had notified the judge of his application dated May 6 and sought the indulgence of the court to recall the first prosecution witness, Mr. Monday Osazua. On April 12th, Osazua, a staff of the CBN, had narrated in court how the former governor, on different occasions, directed him to collect $3 million cash in tranches. Counsel to the Economic and Financial Crimes Commission, Senior Advocate of Nigeria, Rotimi Oyedepo, had no objections to the request. Still in Lagos, the scheduled arraignment of convicted kidnapped Chukwudumeme Onwumadike, popularly known as Evans, was stalled before another judge of the court, owing to the absence of his counsel. Trial Judge Justice Adenike Koka subsequently adjourned till June 13th for the planned arraignment. Evans and his co-defendant, Joseph Ikenna Emeka, are facing an amended 5-count charge of murder, attempt to kidnap, and conspiracy. They allegedly killed one Peter Nweke on August 27, 2013, along 3rd Avenue, Festac Town. The duo were also alleged to have killed one Chijoke Ngozi and attempted to murder and eventually killed the chairman of the Young Shall Grow Motors, Obianodo Vincent. Meanwhile, the prosecutor has told the court that the two defendants had applied for a plea bargain, which was still being considered by the Attorney General of the state. Staying in Lagos, but this time at the Federal High Court, a compliance officer with Zenith Bank, Clement Ngbolo, has narrated how Mr. Abiodun Agbele, an aide to the former governor of Ekiti State, Ayo Fayose, collected a sum of 1.2 billion naira from Musiliu Obanikoro at the Akure airport. While being led in evidence by the prosecution counsel, Senior Advocate of Nigeria, Wahab Shitu, the witness told Justice Nnamdi Dingba that after the money was flown to Akure via an aircraft, Fayose's aide, Agbele, was waiting with some Zenith Bank officials and a bullion van at the tarmac to take custody of the money. The witness testified that after Agbele took custody of the funds, totaling about 1.2 billion naira, the money was moved to the Zenith Bank branch in the state with the bullion van. He said when they arrived at the bank, Agbele instructed that the money be distributed into 3 designated bank accounts, those of the privateer, a corporate account linked to Agbele, Spotless Investment, a corporate account linked to Ayo Fayose, and to the account of Ayodele Fayose himself. The banker also said the sum of 260 million naira was taken to Ado Ekiti in cash. Justice Dingba has adjourned further proceedings in the matter to May 24th for the testimony of another prosecution witness. In Abuja, Justice Emeka Nwite of the Federal High Court has refused to grant bail to an executive of Binance Holdings Limited, Tigran Gambarayan. Justice Nwite held that Gambarayan was likely to jump bail. His lawyer, Mark Mordi, had argued that the court had the power to grant bail to defendants and impose conditions to ensure his presence in court. The prosecution counsel, Ekele Ihanacho, however, opposed the bail application, stating that the defendant was a flight risk. He stated that the defendant attempted to obtain a new passport, which was a suspicious act. The counsel also reminded the court that the defendant was not attached to any community in Nigeria. The case has been adjourned to 23rd May for continuation of trial. In Adamawa State, the State High Court has issued a warrant of arrest against Huda Yunusa Ari, the suspended resident electoral commissioner of INEC. The presiding judge of the State High Court, Justice Benjamin Manji Lawan, ordered the Inspector General of Police to arrest Hudu Yunusa Ari and present him before the court to stand trial on a 3-count charge. The judge issued the ruling based on the application filed on the 16th of April 2024 by the Adamawa State government through its counsel. While moving the application, counsel to the complainant, Leonard Zadon, informed the court that the application was seeking the court's warrant of arrest against the defendant. The trial judge in his ruling said that it was the 3rd time the case was being mentioned without the defendant in court and that it appeared he was evading service. And we round up with the report that the National Judicial Council, under the chairmanship of the Chief Justice of Nigeria, Justice Olukayode Ariwoola, has resolved to issue warning letters to Justice Iyank Ekwo of the Federal High Court and Justice Brinkins Okolosi of the Delta State High Court. A statement by the NJC Director of Information, Soji Oye, says Justice Ekwo is warned for abuse of discretionary power of a judge by wrongly granting an ex parte order in a suit. Justice Ekwo is also barred for being elevated to a higher bench for a period of 2 years. Justice G.B. Brinkins Okolosi, on his part, has also issued a warning for failure to deliver judgment within stipulated period in another matter and will also not be elevated to a higher bench for a period of 3 years. The NJC also cautioned Justice Amina Shehu of Yobe State High Court for issuing writ of possession conferring title on the defendant in a suit when there was no substantiating judgment of any court to enable his lordship issue the writ. The council also resolved to recommend 86 judicial officers for appointments to the Court of Appeal, High Court of the Federal Capital Territory, Sharia Courts of Appeal, and Customary Courts of Appeal of states in Nigeria. All recommended candidates are expected to be sworn in after the approval of the NJC recommendations to the President and their respective state governors.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shieli. Thank you for watching and see you next week.